I'm Jake Linford, the Loula Fuller and Dan Myers Professor at the Florida State University College of Law, and today I'm going to tell you a little bit about contract law. I'll give you a brief introduction to contract law. Now, when we talk about contracts in a law school classroom, there are two foundational questions we're trying to answer. First, what does it mean to say that a promise is legally enforceable? What are the consequences if you and I enter into a legally enforceable contract and then one of us breaks or breaches that contract? Two, how do we distinguish between those promises that are legally enforceable and the ones that are not? Now, in trying to kind of sort through contract law, there are kind of 7 major divisions that we could separate these questions into. What promises are enforceable? When and how do those promises become legally enforceable? What exactly did the parties promise? What types of promises shouldn't be enforced, even if the parties have agreed to them? What conditions or defenses might justify one party's non-performance? What happens when a promise is enforceable? What are the consequences for the breach of a promise? And when might a contract be enforceable by or against non-parties? Now, why do we have contract law in the first place? There are some transactions, some exchanges for which we don't really need contract law. Imagine Jack has apples and Noel has oranges, and Jack wants some oranges and Noel wants some apples. Jack shows up with a barrel of oranges, or a barrel of apples. Noel shows up with a barrel of oranges, and they trade them right there, standing face to face. That's an easy transaction, and unless there's something wrong with Jack's apples or Noel's oranges, we're not going to need the law to come step in and enforce this deal. Now, we might have currency. Jack shows up with apples, Noel shows up with money, but it's the same deal mostly. And if Noel shows up with her money and Jack shows up with his apples, and they are both kind of face-to-face and an arm's-length transaction, we don't necessarily need the law to tell us what to do if things fall apart. But it gets trickier once Jack's buying shipments of something from Noel, and he's using a card to pay for them, and Noel's shipping them after she receives the payment. Then we note there starts to be some uncertainty in the deal. Or if we have a complicated transaction where Jack owns a company and that company is valued in shares and there are multiple shareholders of stock, and Noel wants to buy the company. How do we handle those sorts of deals where there's complexity and the transaction happens over time? Contract law begins to help us sort out some of those problems and provides a legal backstop, an assurance to Jack that when he gives Noel his credit card, that he has some sorts of protections if she doesn't ship the product, or if the product doesn't look like she promised it would look when he purchased it. And Noel has some protections in case Jack's money's no good, or in case the apples she buys from Jack's have flaws or worms or what have you. Now, what happens if one party breaks their promise? Generally speaking, and we'll turn back to this question at the end of this video, generally speaking, the party that didn't break the promise, the party that didn't breach the contract, is entitled to money. And we'll talk about how we figure out what kind of money, what kind of compensation the non-breaching party is entitled to. Now, which promises are enforceable? Sometimes a handshake promise is enforceable. We don't need any sort of writing to commemorate the contract between the parties. There are other cases where we do expect to see a writing, but in either case, what we're looking for is some evidence that the two parties reached an agreement. And there are a certain subset of promises that the parties might have reached an agreement about that we just don't want to fire up the machinery of the courts to enforce. Promises like, I promise to meet you for lunch, a promise of a social engagement, generally speaking, not enforceable in a court of law. Social inducements, I promise you it won't rain on our picnic. Well, I can't guarantee that, and courts aren't willing to hear lawsuits about those sorts of promises either. What we look for when we're looking for an enforceable promise is we're looking for consideration between the two parties, or a bargain for exchange, each party giving something and each party giving up something in order to make the deal happen. Each party gets something they want, each party gives up something the other party wants. You get something, I get something. That's how we know we have a deal that's enforceable. You might get apples and I get oranges. You might get steel and I get money. You might get money and I might get a haircut. Why use consideration? Well, the theory behind consideration is that consideration itself is evidence that a court could rely on to conclude that both parties took the promise seriously. Jack shows up with his apples, Noelle shows up with her oranges. Each one wants the other party's produce. The benefit each party gets from the deal is some evidence that the deal's a serious deal. Consideration, the fact that each party is getting and giving something, might also put both parties on alert or on notice that there's going to be an important change in the relationship. So it serves a cautionary function. We don't accidentally fall into enforceable promises. Third, the consideration might help us keep track of the contours of the deal. We each promise things of value, but our legal exposure to each other shouldn't go much beyond that which we've promised, the consideration we've offered each other. Thus, it channels our obligations or kind of shows the limits to what we've promised each other. Instead of consideration, sometimes a promise is enforceable in the following circumstance. Party A makes a promise that Party A knows or should have known Party B is going to rely on. Party B does rely on the promise to his detriment, and the promise is enforceable even if Party A receives no consideration. So a promise that Party A makes where Party B is not really giving Party A anything, but Party B is losing something, relying to his or her detriment, and Party A knows it, that's an enforceable promise, even though Party A is not getting consideration. Now, how do we know when promises become legally enforceable? Generally speaking, we're looking for two things. We're looking for an offer from one party to another. Now, that offer can be retracted before it's accepted, and then we're looking for acceptance of that offer. That offer and acceptance tell us we have a deal, tell us that the bargain for exchange has been cemented in a way that the law can then step in and enforce it if one of the parties breaks the promise. Now, sometimes we might misunderstand what we're talking about. I tell you I want to sell you my house in Killarn Estates. You think I mean a house in Killarn Lakes. And if we both have a mutual mistake or a misunderstanding about what we're saying, perhaps that promise isn't enforceable because the thing I was offering that you thought you were accepting, they're not the same thing. So there's a mutual mistake that makes the promise unenforceable. Do we have to specify everything in a contract? Not necessarily. Indeed, it's often difficult to do so. If we're talking about sales of goods like apples or computers or Apple computers, we have a law that's enforceable in 49 of the 50 states called the Uniform Commercial Code, and Article 2 of that law has some background rules that are our default rules if we don't specify. So the UCC governs those sales of goods. It's been adopted in every state except Louisiana, not adopted in Puerto Rico. And it specifies some default rules that take over when the parties themselves don't specify. For example, if a contract is silent as to price, it doesn't tell us how much money Noelle is paying for Jack's apples, the price is a reasonable price at the time of delivery. That may sound strange, but the UCC will allow a contract to go forward even if the parties haven't agreed about the price. Now, with a common law, this would be non-UCC law, judge-made law, generally applicable in sales of things that are not goods, sales of real estate, sales of services. That governs, transfers of real parties, some service contracts. The common law also has some gap fillers. For example, in the state of Florida, which is true of most states, courts consider every contract to include an implied covenant of good faith and fair dealing. Now, how strong that covenant of good faith and fair dealing is, how much it limits the parties, that's a question that gets filled in as the cases go on, but it's an example of a gap filler. Now, is it possible to have a contract where one party's bound and the other party isn't? Generally, the law has a preference for bilateral contracts. Each party exchanges promise. Each party is bound when those promises are exchanged, and the promises are enforceable at the same time. Both parties become bound to each other at the same time. There is such a thing as a unilateral contract, where I can invite you to perform and I can tell you the way you accept my offer is not by giving me a promise, but by performing the thing I ask you to do. Your performance then is your acceptance. I'm not bound until you accept by performing, but you're not bound to complete the performance. You are only bound once you finish. That would be a unilateral contract. In a bilateral condition, we can both be bound by the exchange of our promises. In a unilateral condition, the promisor is not bound till the promisee performs, but the promisee is not required to perform. There are some wrinkles that we'll get into in a contract class over the course of a semester. So we now know we're looking for consideration, we're looking for an offer and for acceptance. Then oftentimes when there's a claim of breach by one party, the question is a breach of what? What are the conditions of the contract that the parties agreed to? And so we get into the question of how do we identify our bargain? Does the contract have to be in writing? Well, sometimes. Under the UCC, that's our sales of goods, Apple computers. If the goods have a price of $500 or more, we need a writing that memorializes the sale. If there is no writing, the contract may be unenforceable. Most states have something called a statute of frauds that requires writings in certain circumstances. It's transfers of real property. I'm going to sell you my home, or I'm going to sell you a parcel of land. We expect there to be a writing, and the contract will be unenforceable if there is not a writing that commemorates it. A suretyship. I guarantee to a third party that you're going to meet your contractual obligations, and if you don't show up, I'll show up and do it. So if you've ever had a cosigner on a car loan, that's a simple form of a suretyship. Service contracts that we can't complete within a year, which would include contracts from employment. If the contract's going to last more than a year, we expect that to be in writing. Now, it's not that these agreements are illegal if you don't have a writing, but they're typically unenforceable. Contracts that don't fall into these general categories are enforceable even if there isn't a writing, but it does raise the question, how do we know what the contours of the contract are? And oftentimes if there's no writing, then we get into a discussion where we bring the parties in and they give testimony, they're deposed, juries hear the testimony, and we try to sort out what the contours of the contract are. Contracts can be binding with no writing whatsoever, so long as we've got that consideration, that bargain for exchange, and an offer and acceptance. Now, if we have a writing, we might imagine that the writing governs the entire deal. Generally, that's true, but there are rules for when a party may or may not introduce evidence that comes outside of the writing, where that evidence outside of the writing might change the nature of the deal or might supplement or help a court understand the nature of the deal. Interpreting the contract can also be tricky. We usually spend time in a contract class figuring out how to interpret contract language and how courts make sense of the language that they find in a contract. Now, can a party enforce a contract that was neither negotiated nor read? Imagine the last time you signed up for the Apple Music software license update. It used to be called the iTunes software agreement. That was back when I was first an iTunes consumer. You might have had to click a box that said you agree to this contract, and if you're like me, you probably didn't read it. Are those contracts enforceable? It kind of depends on the notice given to the consumer. Now, imagine there is a contract, it's enforceable and we know what it says, and that one of the parties broke their promise. There might necessarily be a defense to the enforceability of the contract or a justification for breaching the contract. Sometimes we misunderstand each other. You thought I meant one house, I thought I meant another. There's a sale of a cow. You thought the cow was barren, I thought the cow might be pregnant, and if there's a misunderstanding about that, the contract might be unenforceable due to our mutual mistake. Things might change through no fault of either party. You promised to rent me your theater for me to put on my play, and then the theater burns down. Well, if that's not your fault and it's not my fault, maybe we walk away due to the impossibility of you performing the contract because you don't own a theater anymore. Sometimes the deal itself is problematic in the way it was negotiated. There is duress or coercion. One of the parties might be drunk or a minor and unable to commit to the contract to make an enforceable contract due to their incapacity. Now, must the parties do everything exactly as the contract says? Well, sometimes. In some jurisdictions, a contractor on a construction project can't get the last payment until the hiring party is completely satisfied, But in other contexts, courts have softened that rule, or in other jurisdictions, courts have softened that rule, determining instead what we're looking for is whether the demands of the hiring party are reasonable and whether the contractor has substantially performed. Under the UCC, we have an answer that is usually yes, the party must do everything exactly as the contract says. There's a perfect tender rule where the supplier of goods must supply goods that meet the promises of the contract perfectly. That could include warranties, number of goods, when they're going to be shipped, etc. And if I've promised you goods of a certain quality, the goods I provide have to conform. Although the UCC does allow some off-ramps where the providing party, the selling party, gets a chance to bring the goods into compliance if they weren't on the first try. Buyer can reject non-conforming goods, but like I said, there needs to be a window given to the seller to get the goods into conformance. Now, what are the consequences of making a promise enforceable? If party A promised to sell apples to party B and then doesn't deliver the apples, a court's persuaded that the contract is enforceable and that party A breached the contract, what happens? Generally speaking, the dominant measure of damages in contract law is what's called the expectation interest. The buyer of apples expected to get apples at $5 a bushel. And what makes the buyer whole if the seller breaches is expectation damages that would put the buyer in as good a position as he or she would have occupied had the defendant performed the promise. So if I was promised apples for $5 a bushel, and I can go buy replacement apples for $6 a bushel, I'm harmed to the amount of the difference. In other words, I expected to get apples for $5, I got apples for $6, I'm harmed $1 a bushel. If I can find apples for $5 or $4.75 a bushel, I wasn't harmed at all, unless it cost me a lot of money to go find the replacement seller. There is a reliance interest we could use instead. How much money did the promisee spend getting ready to receive the goods, for example? The expenditures in reliance on the promise might be an indication of how much the promisee, the party relying, was harmed. We could have a restitution interest instead, which is to the extent value's been conveyed by one party on the other, that value's got to be disgorged. So if Jack delivers these apples and Noel hasn't paid, one thing we could say is Noel's got to give the apples back, and that seems like a simple measure. There are some other limits on the damages remedy. Can I force you to perform a contract? Almost never. There are some exceptions that we'll get into in a contracts class, but generally the answer is no. Can we set our own damages in case of breach? For those of you who are watching this video in 2022, you might be familiar with an offer by Elon Musk to buy Twitter, and that contract includes effectively a breach of contract clause, liquidated damages we'd call it, of $1 billion. If you walk away from the contract, you owe $1 billion. Courts will enforce those types of damages provisions, those liquidations of damages, if they're not so high or low that they constitute a penalty. Now, generally speaking, the injured party is required to reasonably mitigate or reduce losses that would otherwise be suffered. If Noel needs apples and Jack fails to deliver them, and she's running an apple juice factory, and there are apples on the market, we expect Noel to go buy apples, not to shut down her whole factory and then sue for all those losses. She should mitigate her losses by finding a replacement. The breaching party is also not responsible for unforeseeable damages. Even though I breached, if I had no reason to expect that by failing to deliver a bushel of apples it would shut down your whole operation, you can't get damages that would compensate you for the shutdown of your apple juice making business. Finally, when, if ever, can we bring third parties into a contract, or can third parties sue under a contract? Generally speaking, if I entered a contract with the intent, what you're giving me is a promise you'll do something for somebody else, can that person sue if you fail to perform? Yes, if that third party was an intended beneficiary of the contract. So if Jack promises apples to Noel, and Noel promises to pay money to Jack's business partner, James, James could sue if he's the intended beneficiary of the contract. Now, If Jack enters a contract to do something for you, can he send his brother? Well, maybe. If Jack has unique skills, he's an actor and he's performing in your movie, no, he can't send his brother. But if Jack's changing the tire on your car, his skills are considered routine, then arguably Jack can send the brother in as the replacement. All right, that covers, in very brief detail, how contract law is structured and how contract disputes are generally resolved in courts in the United States. Now, that's a brief overview. Your contracts class that you take over the course of a semester will get into much more detail, but that gives you a sense for what kinds of promises are enforceable and what are the consequences when a party breaches a contract. Thanks for listening.